morning.
Thank you. Good morning, Your Honors. May it please the Court, Ilene Herscher on behalf of the father, Dept. It's my argument, Your Honors, that it was error of the trial court to enter an order of adjudication as to the father, Dept, pursuant to the Florida Statutes 39012 and 39044. Inasmuch as there was no evidence that the father, Dept, and the mother, TW, engaged in domestic violence in the presence of the children, and also that the children were significantly impaired by their alleged exposure to domestic violence.
Some of the domestic violence was in front of at least one child. Well, so don't you have to kind of separate them out into the three different children?
The testimony, I believe, Your Honor, was that two children were not home, that the third child, SS, was initially home up until the time the father came home, and then he left the house. He was not home.
But the witness, the incident of the father grabbing the mother's hair and ripping her clothing was witnessed by Dept, correct? That's one child.
I think the incident we're talking about, this incident that led this case into the court, was not witnessed by any of them.
The last incident, but the previous incident was witnessed by at least one child.
A previous incident. However, this incident, none of the children witnessed. The child that testified he was home, SS, when the father came home, also testified that he left the house after the father came home. He did not witness this incident.
Why did he leave the house?
I'm sorry?
What was his testimony as to why he left the house? Wasn't it because he was looking for one of the other kids, because he wanted the kid to come, the older child to come in and stop this? Because this had been occurring before? It wasn't like he just left to go out and play while mom and dad were arguing.
Well, I believe he testified that he went outside to the street, and perhaps you're correct that he might have told the other child, but he did not witness this himself. And I believe that the third DCA has previously ruled that where there is substantial evidence demonstrating a history of physical or verbal altercation between the mother and the father while the children are home, that is sufficient for an adjudication of dependency. And I'm particularly looking at in the interest of GR versus DCF 2005. Also, the third DCA has ruled in the interest of YT versus DCF in 2006, where the children were in the close confines of the home and relatively close to the parents when they were altercating. That was sufficient for an adjudication of dependency. However, here, for this particular incident, two children were not home, and the one child, SS, although he may have been looking for a sibling to tell him something could happen, left the home after the father arrived. He was not there when the altercation commenced. So I believe the incidents of this particular case are different than the third DCA's case of GR and YT. The history, I don't believe, is sufficient because none of them were in the close confines this time. None of them observed it. Further, the statutes both state 39012 abuse and 39014. Both of them state that whatever happens has to result in mental or emotional health where the children are significantly impaired. In this particular case, Dr. Michael G. Tommaso, a licensed clinical psychologist, testified that the kids are really not doing that badly right now.
Well, but the rest of the sentence was that suffering from depression and anxiety.
You're correct. She stated actually there is some depression and anxiety because of the situation. I agree, Judge Rothenberg.
Isn't that enough? Isn't that enough under the law?
That would be your decision. My argument is that it's not enough.
Where would you draw the line?
Well,
where would you have us draw the line?
I would have you draw the line where the statute says significantly impaired. And in this particular case, I don't think that significant impairment comes under the kids are really not doing that badly now, but there's some depression and anxiety because of the situation. Now, she goes on to say...
If the kid's not suicidal, then it's not, not enough.
I didn't go that far.
If the kid's not in a corner in a fetal position, then that's not enough. you have kids here. I was just looking through the judge's order again just to make sure. I mean, you have two police officers that testified at least to two incidences where the mother stated that she'd had a bad argument with the husband, and one of the children came out running and tried to get between them. The father pulled the mother's hair and was punching her. Another one where Delton witnessed the altercation. And then you have a doctor, you have evidence of multiple domestic violence incidents, and you have a doctor who's testifying these kids are depressed. I mean, I'm a little perplexed at where the trial court went wrong. I mean, you're saying it's not significant enough for a dependency action to take place.
That's what my argument is. Okay. I don't believe it's significant impairment. In fact, the children didn't even want to testify, and even Dr. DiTomaso said that they don't want to have to come to court and say something bad about their parents who they want to protect. I think
don't every psychologist tell you that's normal, even in a home where it's very bad abuse. Children are reticent to come in and testify against their parents. I mean, we can kind of put that aside. I mean, that's kind of psychology 101. Kids are reticent to do that. But keep going. I'm sorry. I didn't mean to interrupt your argument.
Well, that's okay. I just said I've had cases where I have to say kids have testified against their parents. So, but I think that you're right in many cases. But I just believe that
when the doctor starts to see, and I don't know if this is the older child or the middle child, but the one child that was a very angry child and had this confrontational anger, aggressiveness about the child, and he said that this was post-traumatic stress syndrome from witnessing what was going on in the household. At some point, don't you think that it's appropriate for the court to intervene and give counseling to we're not talking about taking the children away from the parents. We're talking about intervening, giving counseling so that these kids don't grow up with that kind of anger and aggression because they're seeing it in the household.
Well, I would agree. There is a point when the court should do that. But I don't think that the court should speculate. And I think that significant impairment is much more significant. And I think that where the children were truly significantly impaired, it would be much clearer. They would have to have, maybe medications. Maybe they would have to be put on all kinds of, medications, maybe be put into a facility. I don't know. In this particular case,
that's when they take the children away, not when they intervene with counseling and
the problem is they had counseling, and it didn't prove to be effective.
Well,
and the judge noted that in her order.
Okay, and my argument is saying, though, that I don't believe that the facts of this case were up to the statute, which says they have to be significantly impaired. That is my argument. And I don't believe the evidence or the testimony showed that they were significantly impaired pursuant to the statute. And based upon that lack of evidence, that the children were present during the altercation, that they were in close confines of the home, as the other two third GCA cases were, that the evidence was insufficient, that they were also significantly impaired. And I believe based on that lack of evidence and testimony, I feel that this order fails to support, I feel that the testimony fails to support the requirements of those statutes. And based upon that, I ask the court to reverse the order of adjudication.
Thank you, counsel.
Good morning. May it please the court, Hillary Kambour for the Guardian Ad Litem Program and Karla Perkins for the Department of Children and Families. It appears to me the court understands the issues before it, that this is an adjudication of dependency, which is an opportunity to heal this family. Clearly, there's testimony, both from the children and from, buttressed by Dr. DiTomaso, that these children have been harmed. SS testified that he was sad, and then dramatically demonstrated it by breaking down on the stand. DS1, I believe it was, testified that he's angry every time, every day. That is a classic symptom of harm resulting from violence in the place that's supposed to be safe. This is the way Dr. DiTomaso describes the injuries that occur when children experience domestic violence in the home. And that is, the home is their entire world.
How old is this child that's angry?
He's the older child. I believe he's 16.
And so aren't a lot of 16-year-olds generally angry?
Your Honor, that's very possible indeed. But what Dr. Dept testified to was that children, especially boys, who watch especially their father be the perpetrator of violence in their home, are extremely affected and often result in this kind of anger. And of course that leads to difficulties with relationships, difficulties with functionality, as this court found in DR, citing the myriad of social science data that shows us that children are harmed as a result and of being aware of violence. And that is what the holding of this court was in DR, buttressed by its holding in YP. And that is that, first of all, if there's evidence of awareness, that is present. And in this case, this court had evidence of awareness and presence. Now, SS directly testified. He said, I saw fighting and pushing in my home. Okay, so there is competent, substantial evidence SS saw physical violence. DS1, I believe, testified, oh no, I never see my parents physically fight, but when they do, I don't feel anything. Now remember, the trial court is the fact finder in this case, and it was clearly reasonable for that court to conclude that contradictory testimony from, I believe, a 15-year-old, that he didn't see anything, but when he did, it didn't hurt. For that court to conclude that this child had seen physical violence. Now, DS1, I believe, I may be getting them mixed up, didn't test, he said it was just verbal. Well, just verbal. This court found, DR, was a case where the only violence that the evidence showed the child saw was verbal. That those parents engaged in physical altercations, but there wasn't any evidence in DR that the child saw physical altercations. Yet the court found that verbal altercations are sufficient. Now, Dr. Dept explained, we're not talking about, fight disagreements between couples. We're talking about the inability to solve a dispute without verbal abuse, without disrespect, without cursing. And Dr. Dept explained the difference there, which this court recognized in DR and in YP. So we have evidence that these children were aware of the violence in his home. SS running outside. He ran outside to get his brothers because his brothers stopped the fight in the past. In fact, I believe it was DS2 said DS1, he wanted to go in there, he'd call the police because he didn't want stuff to get out of hand. This is all evidence that these children knew that these parents engaged in violence in their home. Now, as to harm, in addition to the children's SS's testimony being sad, DS1 being angry, Dr. Dept did, as Your Honor noted, testified about anxiety and depression. He said it wasn't too bad yet, but he also testified these children were at high risk of future harm were they to remain in this home. This is the opportunity to fix this family now and to help these children not repeat what they have experienced in their own homes, in their lives. So we would ask for an affirmation. Thank you.
Thank you.
Counsel.
You may have rebuttal if you wish. You don't have to, but if you wish. Thank you very much.
Thank you both very much.